Hi, I'm John McGowan, General Secretary of the Social Workers Union, and good evening, and welcome to another SWU webinar where social workers get the opportunity to ask questions. It's great once more to see so many people registered, and I can see a large number of attendees for tonight on screen, so thank you again. This is a special edition of the Talk to SWU webinars and produced with the Social Work Employment Service, the UK's only not-for-profit social work umbrella company, providing employment services to independent agency social workers and employment agencies. And indeed, the collective bargaining agreement between SWES and SWU is a commitment to protecting workers' rights, and specifically, in this case, the rights of agency social workers. So thank you. I am hopeful that we'll get through a lot of questions this evening, and do remember that the advice offered for this session is, as of today's date, the 14th of September 2022. The event is being recorded and will be available to review and share soon. Indeed, the last recording reached over 1,500 views, so thank you again. Working behind the scenes are the talented Sean and Joanne, and I will now take you through some of the housekeeping for this webinar. Please do ask any questions in the live chat box to the right of the screen, and Sean and Joanne will be busy and make me aware of them to share with the panel. My advice is to keep comments brief and non-identification factors in any message, just to represent confidentiality. Before I introduce the panel, I just want to emphasise the need to join a trade union. I'm biased, and I would always recommend the only specialist social work union in the UK, which of course is SWU. So SWU working with BASW, and of course SWES is indeed a terrific calibration for the social work community. So now over to the important people in this webinar. I will ask each panel member to introduce themselves, and I'll start with Paul.
Thank you, John. My name is Paul Scoley. I'm a partner at the trade union law firm Morrish Solicitors. We're based in Leeds, but we act nationally for trade unions and associations across the UK.
Thank you, Paul. And Laura, introduce yourself, please.
Hello there. Yes, I am Laura Sheridan. I'm a member of our advice and representation team, trade union official, working for BASW and SWU.
Thank you, Laura and Paul. And like all technology, we'll do our best, and we're working with chat boxes, and I've got a screen to my left. So if I'm looking away, I'm not ignoring everyone. I'm looking at my mother's screen for questions. So I suppose a good opener for Laura and Paul, really, and again, it's about furnishing knowledge, is just for you to maybe give an overview of the different types of agency arrangements for social workers. And that's quite important just to set the scene. And maybe hear from you, Laura, and maybe Paul to add on the different agency arrangements. So you happy to start with that, Laura?
Yeah, I mean, what I'll talk about is the most common ones that our team kind of come across in our work and when we're advising people. Historically, what we used to see is people were agency workers, so they'd perhaps set themselves an own limited company up and work via an agency that way, or they would just work via an agency for local authorities, so they would be classed as what's called a worker, so a temporary worker. What we see a lot nowadays, since IR35 came in, which I believe Paul's going to kind of talk about, hopefully we'll cover that later on. What we tend to see now as the most common arrangement for our social workers that we represent is something called an umbrella company arrangement. So most of the time what we're seeing is that technically the social workers are employees of an umbrella company, and then there is an agency that is used as kind of a middle user to place somebody with a local authority, for example, on an assignment. And so technically the actual employee of the social worker is the umbrella company, and they organise tax, national insurance. They normally charge a fee for sorting all of that stuff out, and then they pay the social worker, for example. So a lot of it depends on what someone's contract says, because they're not always employees, so you really need to have a good look at what your contract says to figure that out. One of the other things that we do see sometimes is that some social workers do work completely self-employed and do some independent work where they might be commissioned by a local authority to do an assessment, for example, a one-off independent assessment that is needed, but they are not generally agency workers. They are normally completely self-employed, independent social workers. So they're the two most common things we're seeing. I know there are potentially other agency arrangements, and I'll hand over to Paul at that point to kind of talk about what other options there may be.
Thank you, Laura. Over to you, Paul.
Thanks, Laura and John. Yeah, I won't talk about umbrella companies. Laura's covered that. I think a lot of social workers do work for umbrella companies. They remain agency workers, and when we come to talk about the agency worker regulations, they can benefit from the rights provided to agency workers under those regulations. In addition, some people will work, if they're working on temporary contracts, directly for, say, a local authority as employees of the local authority, and in that sense they're not really agency workers at all. They're simply on temporary employment contracts. Others, as Laura says, may be truly self-employed, perhaps offering consultancy type services or perhaps educational services, working for themselves and registered self-employed with HMRC. They're not affected by the agency worker regulations because they don't apply to truly self-employed individuals. Other people may contract directly without an umbrella company via an agency to be placed into agency work at the end user, usually local authority. Some of those people will do that privately as an individual who offers their services via the agency to the end user, and in some areas, and I think less so in social work, and Laura touched on this, some individuals will set up limited companies, often called PSCs or personal service companies, and those companies will contract through the agency with the end user, and the individual will be employed by their personal service company. That has become more problematic with the invention of IR35. So lots of different ways in which you can work on a temporary basis for an end user, either through or not through an agency, but we'll be concentrating tonight on those people placed via agencies.
Thank you, Paul. That was clear. And for anyone who's taken any notes, obviously this session is available in catch up, so you can review just to listen to all that again. So there you go. Laura, we've had somebody asking, just to be clear about the difference between an agency worker and an agency worker through an umbrella company like the Social Work Employment Service. Is that something you'd want to have a stab at there? Is that okay?
Yeah, I mean, I think we've generally covered that by our explanations of the different types of agency worker. But basically, if you're employed via an umbrella company, the umbrella company is your very often your employer, sorry. And again, you really need to kind of double check what your contracts say to make sure that that is the case. And actually, it isn't necessarily just about contract. There is case law around it. It's not just the contract. It's about the reality of the working arrangements and who has control. There's all sorts of tests that determine that. But the difference is that you would be technically most of the time be an employee of an umbrella company, whereas if you were just working for the agency, you would be a temporary worker basically, so wouldn't necessarily have the same level of rights as you would as an employee. I think one of the things I'd say, I can't emphasize enough really, and I think I've already touched on it, is if you're going into looking at agency work, temporary work, make sure you check all of your contracts. If you're doing it via an umbrella company, check what your contract says, check what the agency contract says, make sure that they are clear and you're clear about it. And actually, even if you're thinking of doing kind of stuff, some independent work as well, or setting up your own limited company, you need to get some advice on that. And that's more around kind of tax advice and kind of, so it's worth getting advice if you're thinking of going down any of that routes from somebody who specialises in that area, and it's more around accountancy advice and tax advice, because you don't want to end up in a situation where you think you're self-employed and you're not, and then you're liable for tax and that kind of thing. So it's always worth getting advice on that sooner rather than later, and double checking you know exactly what you are in terms of your employment status and who's liable for paying that tax really.
Thank you, Laura. And just to reinforce to anyone to remember who's joined us, to remember to get any questions in in the chat box to the right hand side, and we'll do our best to answer them. We've got a few questions in already, but Paul, are you happy with that explanation regarding the difference between agency and umbrella?
Yeah, I think Laura's covered most of it. Perhaps one or two practical examples of what the excuse me, what the difference might be would help illustrate what Laura was saying. So, for example, as a traditional agency worker who's not employed by an umbrella company, then your rights working for the end user, local authority say, will not include sick pay. And certainly they won't include parental leave. So there are fewer rights for an agency worker in that sense with the end user than for an employee employed directly by the end user. However, some umbrella companies, because they're employing you directly, may provide in their employment terms and conditions that you will get sick pay or that you will get rights to parental leave, maternity, paternity, adoption leave, and so on. So the umbrella arrangement can offer a more employment-like arrangement than a traditional agency placement for an individual.
Thank you, Paul, and thank you, Laura, for answering that. The other biggie we've got in at the moment is someone's asked, what is IR35? So quite a general question, but would you be okay trying to answer that, Paul? And then we'll go to Laura as well.
Yeah, it's complicated. Perhaps the background of it is worth briefly looking at. The government and the revenue in particular were concerned a few years ago that lots of people were pretending to be self-employed when in fact the work that they were doing was more in the line of employed work. This was often referred to as bogus self-employment, and the revenue calculated that the tax coffers were losing millions of pounds a year because, as a rule, self-employed individuals can get preferential tax treatment compared to workers who pay by PAYE. So if you understand that that was the background to the problem from the government's point of view, then IR35 was the rather heavy iron boot that was used to stamp on these bogus self-employment arrangements. And what IR35 says in a nutshell is that if looking at the self-employed arrangement that you have, if in fact, but for the description that you've given it as self-employed, it would otherwise look and feel and operate like an employment relationship, then IR35 intervenes to say, okay, even though you say you're self-employed, we're going to treat this for taxation purposes as if you're a PAYE employee. And usually the end user will end up having to pay tax direct to the revenue. And that's one of the reasons, and Laura mentioned this earlier tonight, that's one of the reasons that umbrella companies became popular, because they avoid the need for IR35, because the umbrella companies will look after the question of PAYE taxation, for example. But for those people not working for umbrella companies and describing themselves as self-employed, then they need to be aware that just because you say you are, it ain't necessarily so. An IR35 can operate to enforce a PAYE taxation system, even if you, in other respects, seem to be operating on a self-employed basis.
Thank you, Paul. And Laura, would you like to add anything to that? Are you happy with that description of IR35?
I think Paul's explained the description very well, actually. I think I would just go back to emphasising what I said earlier in terms of making sure, if you're going down this route, to get the right advice to stop you getting stung, I suppose, further down the line. Because when IR35 did first come in, for the first, I'd say, year or so, our team were quite often getting calls from members who had either kind of not fallen into thought they were self-employed but ended up falling into IR35, for example, and been liable for a tax bill, which is something that we couldn't really support with very much, because again, it was a tax issue rather than an employment issue. So we could advise as much as we could, but it was limited. But the other issue we had as well was around, we had some people that had signed up for not necessarily very good umbrella companies, to put it politely, that had said they were taking tax and national insurance, but had never actually paid it to HMRC. So then they had big bills from HMRC, and because they were the employee, they were liable for that tax. So it's about making sure that you get your advice properly, you check out your umbrella company properly and make sure they're a legitimate one, like SWES, for example, and that you're not going to be put in that position where it's almost, for me, if it feels too good to be true and you're not paying as much tax as you think you should be, you're probably not paying enough tax, and HMRC will catch you at some point, and you are liable for that. So just make sure you get that advice and check things out properly when you're going down this route, really.
If you look at
words of wisdom there.
Sorry, can I just?
No, you go, Paul.
Just to pick up on Laura's point there, if you Google umbrella companies, there's a really useful kind of fact Q&A FAQ on the government's sorry on the government's website, and it discusses at some length the question of fraudulent umbrella companies, because quite a lot of them will advertise that you can save tax by going through them. And as Laura says, as a rule, you're not going to save any tax at all, because you're going to pay PAYE as if you were an employee. So if they're saying that there's some tax saving, then probably it's tax evasion, which is illegal, and you don't want to participate in it, or it's a fraud on you as well, in the sense that they're deducting something from you and not paying it over to the revenue at all. So worth looking at that website. If I can find the link, I'll post it in the chat.
Thank you, Paul. Thank you, Laura. Words of wisdom, as I said. So that's good. Keep the questions coming into the chat box. If you've got one and it's really important to you, please put it in. We'll consider it. We've got 40 minutes left and only a few questions to go through. So keep them coming in. The next one, Laura, somebody's asked this question. Does an agency worker have the right to holiday pay, and does my agency pay me sick pay when I'm a temporary worker? So we'd like to try this one. So again, it's, does an agency worker have a right to holiday pay, and does my agency pay me sick pay when I'm a temporary worker?
In terms of the holiday pay, the simple answer is yes. Agency workers, temporary workers do have a right to holiday pay. If you're self-employed and you're completely self-employed, then no, you don't, because you're completely self-employed, so you're responsible for sorting out your own holidays. I think the issue of sick pay is a little bit more complicated, because I think it depends what your working arrangement is, for example. So if you're an agency worker and just employed by the agency, probably not, because normally agency workers don't get sick pay. Temporary workers don't get sick pay. They only get paid for the time they're in work. If you're employed by an umbrella company, it will depend what your umbrella company's sick pay policy is. So again, you need to check what your contract says, because nobody is technically entitled to sick pay. In terms of people are entitled to statutory sick pay if they've worked for so long normally, but even people who are employed, most social workers work for local authorities if they're employed, and most local authorities will have a sick pay policy where people will get paid maybe full pay for 3 months and half pay for the other 3 months, for example, but they don't have to do that. So actually they only have to give you statutory sick pay. So even as an employee, you're not necessarily entitled to, full sick pay from your employer. It really depends what your contract says. And if you're working for a private organisation, which I did, for a couple of years when I was a social worker, you got sick pay for a couple of weeks if you were lucky, and that was at the discretion of your manager. So it really depends on what your contract says and whether you're employed or whether you're an agency worker. So you need to just kind of double check what your arrangement is, really.
Thank you, Laura. And Paul, do you want to add anything to that? Are you happy with that description regarding holiday pay and sick pay?
I agree with Laura. Perhaps I can add something that takes us down a slightly different path onto it, but it's in relation to holiday pay, and it's quite a current issue in employment law. Often, particularly for workers who don't work 52 weeks a year, but who have a series of shorter contracts, it can be common for some employers to try to pay holiday pay on what's called a rolled up basis. And historically, they've often done that by increasing your weekly pay by 12.07%, which is the percentage that the holiday weeks in a year bears as a proportion to the number of worked weeks in a year. And the Supreme Court about 2 months or 3 months ago, in a case called BASW, has held in effect that that approach is no longer the right way to do it, and that instead what you should do is look at a 52-week reference period prior to your holiday and calculate average earnings over that period to determine what your holiday pay should be. And that will certainly mean that for some part year workers, they can be significantly better off under the BASW approach to holiday pay calculation. In that case, Mrs. BASW received holiday pay equivalent to over 17% of her standard pay. So it's, I mentioned it, it's a tangential point, John, hope you don't mind it, but it's of general interest, I think, to workers who might be paid rolled up holiday pay.
Thanks, Paul. It's a useful addition to that. There's another question here, Paul, since I've got you on, and then we've got, I'm an agency worker, but not sure of my main employment rights compared to permanent employees. Would you okay, have a go at that, and then maybe you can add to that as well, Laura? So, Paul.
Yeah, happy to tackle that, John. Agency workers have fewer rights as a rule than full employees. I'm going to distinguish here again, and I'm sorry with it, Laura and I have to keep going back to this, but it's inevitable because of the nature of the beast. If you're working for an umbrella company, then you're employed by that umbrella company, and your rights as against the umbrella company are going to be the rights of a regular employee. But if you're working as an agency worker in the traditional sense for an end user, then you're not employed usually by that end user, and your rights are different. And I've already mentioned earlier tonight that you're not likely to get sick pay, you're not likely to get maternity, paternity and adoption leave rights. In addition, you do not qualify for redundancy pay, and you don't qualify for unfair dismissal rights in the event that you're dismissed. You do, however, get a number of day one rights as an agency worker. You're entitled to the national minimum wage, you're entitled to statutory 5.6 weeks holidays, you're protected from discrimination as if you were an employee, and you have the same rights in relation to whistleblowing, and also from day one you're entitled to, for example, childcare, creche services provided to other employees, car parking, transport and similar services. You can then get additional rights once you've been working for 12 weeks on the same assignment, and on that, at that time you become entitled to rights that are compatible with people who are employed on a full-time permanent basis instead of being agency workers. So some improvements over the last few years in relation to the lot of agency workers, but still a diluted form of rights compared to traditional employees.
Thank you, Paul. And Laura, anything you want to add to that about the main employment rights compared to permanent employees?
Only one thing, and it's just around the kind of whole unfair dismissal claim that you wouldn't have if you were an agency worker. So if you've been an employee of an organisation for 2 years, if they dismissed you in a manner that was deemed to be unfair, and there's all sorts of law around that I won't go into now, but you do have the legal right to bring an unfair dismissal claim. You wouldn't have that if you were an agency worker, even if you'd worked for them for 3 or 4 years as an agency worker. So it's just about highlighting that it's far easier for your contract to be terminated as an agency worker, because normally you'll have a contract that says either party can terminate the contract with a week's notice. Quite often is what we see, and that does happen. You know, if you're no longer required, you can be kind of out quite quickly, because that's the nature of the temporary work, really. Right,
thank you, Laura. And another question just came in live, just asking for for the panelists to expand on something, and the person's asking, some people bound around different terms depending on who you speak to, and I wondered if there is a difference between a sole trader and the personal company option. So again, they're looking at the difference between a sole trader and the personal company option. Paul, are you okay? Just expand for that member who's asking.
Yes, certainly. So as a sole trader is just an individual working as themselves. There's no corporate setup, there's no company name, there's no limited liability. They're taxed as an individual, not a corporation, and so on. By comparison, the personal service company approach means that you need to have, and you can buy limited companies, they're called off-the-shelf companies. In fact, you can buy companies quite cheaply these days and appoint yourself a director, and you can work for that company, and then you'll have certain benefits. You might get tax advantages. You get the benefits of limited liability. If things go wrong, then the company can go bust, but you don't lose your house. Really, you need to speak to an accountant about which is the best vehicle these days, partly because of IR35, and certainly I think in the social work area, the personal service company approach seems to me to have probably become less and less popular. So chances are, if you're not working for an umbrella company, you'll be a sole trader, which is, as I say, just a person working for themselves without the surrounding technical and administrative functions, I guess, and obligations and responsibilities that go along with running a limited company.
Thank you. And Laura, there's a question in, but I think it was covered previously, but we'll answer it anyway. But do I have parental rights as an agency worker? You know, you're happy with that one, Laura?
Yeah, and again, it depends very much on how you're employed as an agency worker. So if you are employed by the umbrella company, they are your employee, and if you're an employee, you are entitled to paid time off for antenatal appointments, for example, and that kind of thing. So the same way that any employee would be. But you need to check what your contract says with regards to that, because whilst you would be entitled to that from your umbrella company, I did have a case fairly recently where I advised somebody in which, yes, their umbrella company paid them their, for their antenatal appointments, but actually when we looked at how their wages were broken down, and it was quite complicated, but actually their hourly rate was only minimum wage, and the wage that they'd been receiving had been topped up somehow by, it was like a bonus pay effectively, that they used to top it up to make it the agency rate, so to speak. So the person was actually entitled to less pay an hour than they thought they were going to be, because it wasn't the hourly rate they'd been used to. So there's all those kind of technicalities that can come into it. But if you're employed, then you're entitled to the same rights as an employee would have, and the employer is your umbrella company.
Thank you. Anything you want to add to that, Paul?
No, I think Laura's covered it.
Good. Somebody's commented on one of the questions. It's not only agency workers you cannot put on unfair dismissal, only apply to permanent staff under 2 years. Would that be right? But we can come back to that. So I'm not sure what that one is. But the next question, Paul, we've got, if you don't mind answering that, it says, what protection do I have under the Agency Workers Regulations 2020? Can I be dismissed after 11 weeks?
Right, so the rights that I talked about a few minutes ago that kick in at the 12-week point are rights that an unscrupulous employer might try to avoid by preventing you getting in your 12 weeks. And at one point it was thought that employers would employ for 11 weeks and then bring the contract to an end. And a week later they'd start another contract which magically came to an end after another 10 or 11 weeks. In fact, now the Agency Workers Regulations under Section 9, I think, contain anti-avoidance provisions that are designed directly to prevent that sort of behaviour by companies and organisations that are employing agency workers. So provided that you've worked at least twice, either for the same organisation or two connected organisations, then it's possible to look at the structure of the working arrangement, and if that structure appears to be designed specifically to avoid you getting your rights, then you can ignore the structure. In other words, you get the rights anyway, despite the fact that you appear not to have had 12 continuous weeks. Very useful. It means the employer can't use artificial contract structures to deny you the rights that you're supposed to get after 3 months.
Thank you, Paul. Anything you want to add to that, Laura?
I think Paul's covered it.
Good. So while I've got you there, then just looking at the question there, is it advantageous to have a contract for self-employment work? So again, is it advantageous to have a contract?
I'd say it's advantageous to have a contract for any type of work you're doing. I think for me, if you've got a contract, it's very clear what everybody is agreeing to do, what the employer is agreeing. And with self-employed work, it's about actually you're very clear about what services you're offering, what your rate of pay is for those services, how someone is going to be paying that, you know, what the method of payment is, and how each party can terminate that arrangement, that kind of thing. Really important, I think, for any area of work. Again, if you're looking at, you know, being an employee, if you've got a contract of employment that clearly sets out what your employer is offering you, you know, all the terms and conditions of your employment, you've got something to refer to if you need it, and you can read it and be quite clear on it. So absolutely, I'd always say make sure there's a contract in place for any type of work you're doing, and then everything is really clear in terms of who's responsible for what and what everybody's obligations are.
Thank you, Paul. And I'm going to ask you, but I think I know the answer. I take it you would suggest to get an employment contract as well.
Always, whether you're self-employed, employed, a worker, have your terms and conditions clearly set out. Of course, if you're an employee, and that would include an employee of an umbrella company, then the Employment Rights Act 1996 has a requirement in law that when you start employment, you should be given what's called a written statement of particulars of employment. And that includes a shopping list of over a dozen things, such as location of work, hours of work, pay, holiday arrangements, training, disciplinary, grievance, pension, trade union involvement, and so on. All of which have to be set out in writing to you at the beginning of your employment, and employers are breaking the law if they're not providing that to you. That wouldn't apply, of course, if you're self-employed, but nevertheless, what we tend to find as lawyers is that people think they don't need contracts until a dispute arises. And it's at the point that things fall apart that you wish that you'd got the paperwork in place at the outset. So do your homework early, get everything agreed in black and white and in as clear a form as you can. And then if a dispute does arise, you know what your rights are.
Thank you, Paul. And just to remind everyone to get the questions in, I've got maybe 1, 2, 3, maybe 4 questions in at the moment. So we've still got time if you get a question in. There's over 20 minutes left in the session. So again, this one's quite pertinent actually when we think of the cost of living crisis and obviously the ongoing fuel prices. The social worker is asking, you know, he's maybe looking up to pick up extra hours, and the question is, I am working full time for a local authority. Paul, if you don't mind answering this would be great, and then we can get maybe Laura coming in. The question is, I am working full time for a local authority. I'm thinking of picking up some independent work to do alongside. What would what would be your advice in terms of taxes on the independent work, and also what is the maximum number of hours someone can work per week, and is there a legal requirement in relation to this? So there's 3 strands on that. So advice in the terms of paying the taxes for independent work, the maximum hours that you can work, and is there a legal requirement? So Paul, there's quite a lot there. So I don't know if you want to digest some, and then we'll come to Laura. So,
thanks, John. Yeah, good question. I'm sure more than a few people will be looking to extend the work that they're doing in the coming months. Taxation is really a question for an accountant, but I can say this much. In principle, you can have multiple employments, and each of those employments can be conducted on a PAYE basis. There's no reason why you can't receive PAYE taxed pay from multiple employees. But the question suggests that perhaps the other work will be done on a self-employed basis, and in relation to that, you'll need to do a tax return. There's no way around it. If you've got earnings that are not taxed at source, either through regular employment style PAYE or the intervention of IR35, then you'll be responsible for declaring the additional self-employed income to HMRC on your annual tax return. In relation to hours, good question. I think it's widely thought that you can only work so many hours. In fact, in the UK at least, that's not the case. You can work as many hours as you wish to work, but employers can't compel you, with certain exceptions that we needn't go into, to work more than 48 hours a week. Many employers will have contracts that contain an opt-out in relation to the working week, which says you agree where necessary to work more hours than that. But you can't be forced to sign an opt-out. And at any stage, if you have signed the opt-out, so you agree to work longer, you can always, without penalty, withdraw that agreement and say, no, I don't want to work beyond those hours every week because it's too much. So the distinction really is between the law allowing you, if you wish, to work extra hours, but your employer not being able to compel you to start working 50 or more.
Thank you, Paul. And of course, Laura, in the social work world, just going back to that need to, to cover the cost of living, I think we'll maybe find more and more workers taking on extra responsibilities. Anything you want to add to that, Laura?
Just one thing, really. I mean, I think you're right, John. I think people are going to be looking for extra sources of income. Social workers aren't exactly paid a fantastic salary for the work that they do. We all know that. But I think one of the things I would say is that it's not a legal thing, it's more of a practical thing, but could get you into difficulty, is if you're planning on doing any kind of self-employed work or any work in addition to what you're employed to do, I think your employer is likely to have something in their policies, terms and conditions that say they want you to tell them and to let them know about that. So I think it's probably a good idea just to make sure that you don't breach any policy or procedures, to make sure that you tell your employer that you're planning on doing that independent work or extra work outside of work, and do it in writing so you've got evidence of the fact that you've done it, because then if you have breached any policy or they say you've breached a policy, you can clearly demonstrate that you've told them that you're doing it.
Thank you, Laura. And just again, get your questions in. We've got 2 questions left in the inbox at the moment, so we've still got time. So if you're feeling shy, just type away and put that in the chat box and we can have a look at it. So Laura, since I've got you there, you happy having a go at this question? It says, what happens if someone I work with complains about me? What recourse do I have? And I think this was in relation, someone says, to their being a contract was terminated and a referral to Social Work England. So it's quite social work specific. So is that okay, Laura? Again, something happens about the recourse if someone complains about them. Yeah,
I mean, I think, again, because of the nature of this webinar, I'm assuming this person is potentially an agency worker, but there would be, the rights you have would be different depending on what your employment status is. So if you're, judging by the nature of the question, I'm assuming that they've received a complaint about an agency worker, and this is my presumption. And as I said earlier, it's far easier to just terminate an agency worker's contract. If you're not happy with their performance, you can just give a week's notice, and normally that's what the agreement is with an agency worker. So a lot of the time what we see is that employers will just think, well, they're an agency worker, we don't need to spend the time and effort doing an investigation or a disciplinary, we'll just terminate the contract and get another person in place. And we do see that happen, unfortunately. Whereas if you were an employee, and particularly if you'd worked somewhere for over 2 years, the employer would be far more careful, because if they're looking at terminating your contract, they would need to go through a proper process to do so, do a proper disciplinary investigation, and have a proper hearing, and then be entitled to representation with that. So in terms of the recourse, it would depend on what your employment status was. If they've dismissed your contract and you're an agency worker, you probably haven't really got much recourse in terms of that. If they've referred you to SWE, that is a tricky one, because I think you need to get advice on that one, really. We do offer advice and representation on proceedings in SWE, and we are kind of quite regularly representing social workers with regulatory body stuff. And I think as soon as you're referred to the regulatory body, you need to contact their A&R team and get specific advice on what is likely to happen, because normally Social Work England will triage what the referral that they've had in. They will decide whether or not they need to investigate it further, and if they're investigating it further, you need to get advice from us as to how to respond to that, or what to expect from that, etc. And you need to do it sooner rather than later, because there's things we can advise to try and make it as, it's never going to be stress-free because you're facing your regulator, but in terms of what the regulator is looking for in your responses and that kind of thing. So I think in terms of recourse, it depends whether you're an employee or not. In terms of Social Work England, it's a whole different process to an employment law process. It's very different. It's a completely different area of law. You need to get advice on it if it's going to be investigated further before you look at responding at all to any allegations.
Thanks, Laura. It's also worth saying about the 3 other regulators in the UK as well. So
of course, yeah, we represent with all of the regulators within the UK.
Yeah, thank you, Paul. Is there anything you want to ask to that? Regarding the question about the complaints and the recourse?
I think Laura's covered that really well, John. Thanks.
Perfect. So since I've got you there, then if you don't mind, the next question: what happens if I'm injured at work as an agency worker? So really someone's asking about if they're injured as an agency worker. Paul, would you be okay having an attempt at that?
Yeah, sure. The chances are that you'll be in an environment that is in some way controlled by, say, a local authority, the end user, if you're an agency worker. And it'll be their premises or their clients or their staff that in some way cause or contribute to the injury that you have. If it's I don't know, if it's a trip at work because of an electrical cable that's been left in the wrong place, then it's that organisation in the end that is liable to compensate you for your injury at work. So even if you're working for an umbrella company and you're an employee of the umbrella company, then subject to the terms of your contract with them, chances are they're not going to be liable for an injury that they have got no part to play. Probably their only role is that they've referred you, say, via an agency to a social work team. And so it can't be said that they're to blame for your injury. And we still have a fault-based damages system for accidents at work. So unless you can establish that somebody was negligent or in breach of some other legal duty that they owed, then you don't get compensated at all as a rule. But it seems to be that most agency workers will be able to make a claim for work-related injuries subject to proving fault against the organisation they're working for in just the same way as a full-time permanent employee of that organisation will be able to make an accident claim.
Thank you, Paul, and thank you earlier, Laura. And I'm always amazed how many questions we've got through. I think we're now on question number 12, I think. So it's the last question I've got in. So unless anybody's got any more burning questions, we'll answer this question, see if anything comes in, and we'll maybe conclude. So here's your chance to get your question in. So Paul or Laura, it's quite specific, this question, and whoever's feeling comfortable to answer it, just shout out. But the person's asking, as an agency worker after 12 weeks, you can opt out of the pension under the umbrella option. I take it, you can, or can you opt out of the pension under the umbrella option in terms of the company contribution? Would the agency worker pick up this cost? So as an agency worker, after 12 weeks, you can opt out of the pension under umbrella option in terms of the company contribution. Would the agency worker pick up this cost? So I don't know if that's too specific, but any offers there?
Shall I have a go?
I'll let you have a crack, Paul.
I'm not 100% sure what the question drives at, but let me make an assumption that you are automatically enrolled into a pension these days if you're working for an umbrella company. If you're employed by them, you'll have pension rights, and every organisation has to auto-enroll you into a pension scheme, but you don't have to remain enrolled once that auto-enrollment happens. You can opt out if you decide that you don't want to do it. Now, for most people, it'll pay to be in a pension scheme. I'm not a pension salesman, but by the way, I get no commission for this, but you'll pay your contribution towards the scheme, and the employer will have to pay a percentage of your pay into the scheme too. So it's free money from your employer, although you might not be able to access it until you're 65 or 7, or as things are going, 77. If you opt out of it, then you'll cease to pay your contribution, but it's a complete opt-out, so the employer will cease to pay their contribution too. And I think that was what the question was aimed at. Can you opt out and keep the employer contribution? And the answer is no. It's an all or nothing opt out. You either stay in, you pay your bit and the employer chips in too, or you come out and you have no pension at all. Does that make sense, John? Laura?
Yes, actually, well done. Laura, I'm sure you're really keen to expand on that one.
I think Paul did a beautiful job of that. John, I'm not going to expand on that one at all, because I think Paul kind of did well, kind of based on the presumption from the question. But I did kind of want to just expand, going back a bit really, on the health and safety issue and a social worker being injured at work as an agency worker. Just to put what Paul said legally into perspective for a social worker, because I think Paul talked about slips and trips at work, but actually social workers are more at risk, I think, because of the nature of the lone working that they do, and going out on visits and going out into volatile situations. So when Paul spoke about the employer being at fault, it's about proving whether an employer was at fault in that kind of situation, because an employer can't predict what a social worker is going to go out to every time. But what they should have in place is a lone working policy. They should have a policy in place where somebody's able to, I don't know, a WhatsApp group, for example. So when someone's finished a visit, the rest of the team know where they are, that kind of thing. And actually, if the employer knows the social worker's going out to a situation that's potentially going to be volatile and difficult, or they're going out to someone who they know has a history of violence, then there should be things in place to protect that social worker. For example, joint working, does it need to be arranged with the police? So if the employer fails to do that, then potentially they're at fault. Whereas if they had no idea what someone was going out to before they went, potentially they're not at fault. But it's not that usual that you want to have some information about somebody before you went out into it. So I suppose it was just about kind of putting that into context in terms of the realities of the risks that social workers face when they're doing their frontline work.
Thank you, Laura. And we've got just one member asking us to expand on, again, it's something to do with the pension, so only answer it if you feel able, Paul and Laura. But just before I do that, just to bear in mind that obviously you're listening to SWU and employment questions. If you want to find a bit more about SWU, have a look at in the link box. We've got a campaign fund, and we've got lots of campaigns going on, so that link will be on any minute now, so please have a look at that. So back to the question, and again, this is the last expansion we've got, unless somebody gets a quick question in. And again, this is just for clarity. So the member's asking, I'm moving to agency work, and usually a company makes a contribution to the pension along with the employee. So who is liable for the company's contribution? So I don't know, Paul and Laura, if it's something that you want to stab at.
Yeah, that makes sense. I think this is presumably a clarification from the previous questioner. So that it depends is the answer, I think. If you're working for an umbrella company, then you're employed by that company, and that company will auto-enroll you into a pension, and they will pay your pension contributions, I think, although Laura will correct me if that's different for SWES, but I think that's right. If you're working via an agency, then I think an agency has an obligation within 3 months to auto-enroll you into a pension too. It depends who pays you. It's the person who's paying you. So if you're getting paid by the agency, then they'll be responsible for the employer contributions, and you'll obviously pay your own personal contributions. So yeah, the identity of the payer is the person who also pays your pension contributions, if that makes sense.
Thank you, Paul. And Laura, you'll be keen to expand on that one?
All I was going to say is it depends who your employer is as to who pays it. And actually, I was going to say as well, because I'm not overly keen on expanding on pension questions, not because I don't want to, but actually I think it's quite a specific area of law, and we have to be very general about what we answer. And I tend to direct members, if they want specific advice on pensions, to the Pensions Advisory Service, which tend to be quite good and can give much more detailed advice on pensions in particular.
Yeah, thank you very much. And obviously, if anyone who is a member of SWU or BASW, then they get access to the to the duty desk. So anything that we've not answered or anything you can think, they can have a discussion. And we have the allocation from the busy A&R team who do a great job for BASW and SWU. So I think I'm just going down here now. I'm looking at any questions coming in. So there's nothing there. So it's almost session is over. So Laura, any concluding comments? Just saying goodbye to everybody. Is that?
I'd join a union, and obviously SWU is the best one, of course.
Thank you, Laura.
No, what I would say is, having done this job for the time I've done it now, the biggest thing I could say to anybody is always make sure you're a member of a union, because you may never need it, but if you do, you really realise the value of it. So yeah, tell anyone you know to make sure they're in a union, and of course this one's the best one.
Perfect. And Paul, thanks again for your high knowledge and for being part of this. Anything in conclusion?
No, been a good discussion, some good questions. Thank you everybody who's come online to see what we've got to say. As Laura says, we can only talk in general terms at these discussions. If you've asked kind of detailed questions and we've not got to them, then sorry about that, but online webinars are not the best format for dealing with issues that require really specific advice. But I hope that some of what we said on a general level has been of interest to you. Thanks, John.
Thank you, Paul and Laura, and thank you behind the scenes working so hard as Sean and Joanne. So I'll say good night to everybody and look forward to the next Talk to SWU session. So bye now.
Bye.